So joining me now, Andy Birchfield.
Birchfield.
Andy, what firm are you from?
Beasley Allen in Montgomery, Alabama, and Atlanta.
Okay, and so you are working on the Johnson & Johnson case.
Yes.
Just for listeners who are not familiar with this case, before we get into the specifics of where it is now, can you give just a slight history on the case for us?
Sure. This litigation's been going on for a little over 10 years, and it involves Johnson & Johnson's baby powder, their talc-based baby powder that has been shown to contain asbestos. So it causes ovarian cancer. And that's what we're litigating. We're litigating now. It also causes mesothelioma, and J&J has recently settled most of their mesothelioma cases, but we're litigating on behalf of ovarian cancer claims. There are about 57,000 cases that are pending in the multi-district litigation in New Jersey, but we represent. And we represent a significant number, over 10,000 claimants ourselves. Beasley Allen does, but we also serve in leadership in the MDL. My law partner Leo Dell is co-lead of the MDL, and so
that's the multi-district litigation. And this is where you have different cases that are essentially consolidated into one case.
That's right. That's exactly right. So when a judicial panel on multi-district litigation decides that, hey, it would be in the best interest of all parties if this is consolidated, streamlined discovery, bring all the federal court cases together in one place. And that's what the panel did in 2016. And so it's formed in New Jersey.
So when we're talking about either the mesothelioma, but the ovarian cancer, that is a function of what was in the talc.
Yes.
Mm-hmm. What are the elements of the case that need to be proved to show, for this case, essentially, what are the components? In other words,
mm-hmm.
how much liability, intent, or knowledge, and then damages?
Yes. Okay. So first of all, you have to show that there is a scientific basis, a causal link between the product, the baby powder, and the injury that that the plaintiff is suffering. In our case, ovarian cancer, and so that link is very strong. I mean, J&J one of the things that we have seen and that we've learned through discovery is that J&J they have known that there's a link between their baby powder and the asbestos in their baby powder and ovarian cancer for decades, going back in the 50s and 60s.
I mean, we've known about asbestos being problematic for that long.
Absolutely.
I have to say, there's a lot of people probably listening right now. Is how does a company know? I mean, asbestos.
Mm-hmm.
I'm of the age of and I remember this became a big deal, and I also now am aware, if you've got to abate asbestos in
mm-hmm.
a place, it's incredibly expensive because it's so dangerous.
Yes.
How does a company justify? This is just like an individual working at Johnson & Johnson. We have asbestos in our powder. Isn't that a problem?
Well, they have made a very dedicated and elaborate effort to cover up the fact that they have asbestos, and they will deny it. They'll deny that there's asbestos, in their talc, although there's been test after test after test. Their own testing for decades has shown that there is asbestos in their talc, but yet, I mean, it's what we're seeing over and over again. You deny it over and over again. You deny it loudly and cause doubt.
What is the function of asbestos in talc? In other words, why would they just take it out?
Yeah, the problem is, so talc is a natural mineral, and when with your talc mines, there is asbestos veins that run through it. So it's not a matter of being able to to remove it. That would be a costly process. So removing the asbestos from the talc is really difficult. But what we have seen, and what's so egregious here, is that J&J for decades has had a safer alternative. they could have, instead of using a talc-based baby powder, they could have used cornstarch.
Right.
And in fact, that's what's on the shelves today. You go to, that's what J&J is. They pulled talc off the market, talc-based baby powder off the market in the U.S. since 2020, and they have cornstarch. But they knew that. They had a patent for the cornstarch decades before. They just chose not to do it.
Why?
Because baby powder was their iconic brand, and they just didn't want to. I mean,
They didn't want to mess
grappled
with success.
right? And part of that seems to be part of their elaborate cover-up effort as well.
And okay, so where, I mean, I want to sort of circle back to this, but let's get through sort of the details, because I'm just curious as a lawyer, like when you come across this stuff, like how it blows your mind, I would imagine. But where are we in the process now? Like, so they have settled or come to an agreement on the mesothelioma side, and this is presumably I would imagine impacts babies. Your cohort is probably more, is it
women,
more
yes.
Grown adults, but I would imagine babies,
Mm-hmm.
it's in the air and you're sucking it in as if you're working in asbestos abatement.
That's right.
Without a mask on.
For the mesothelioma, I mean, you had mothers that were using it as they're diapering their babies. You have babies that were exposed to it, throughout their throughout their growing up years, and so that would lead to the mesothelioma. But J&J, one of the things that J&J did decades ago was they began marketing the baby powder to women for feminine hygiene purposes, and that's what leads to the ovarian cancer development in women.
And so what's the status of that of those cases?
Okay. So we began filing cases. There were a string of verdicts in 2016, 2017, 2018, and then as more and more cases were being filed, J&J was facing more and more lawsuits and trials going forward. Then they pivoted and they filed bankruptcy. Not for J&J itself, but they did what's called the Texas two-step. And they take a subsidiary, they moved that subsidiary to Texas, they split that subsidiary in half. It's called a divisive merger, and they put all of the assets in one company, moved it back to New Jersey. They put all the liabilities, all of their talc liabilities, into a separate subsidiary, and then moved that subsidiary overnight to North Carolina and filed bankruptcy in North Carolina for all of its talc liability, just that subsidiary. And so,
okay, so let me ask you this: what is it about Texas law that allows for that, as opposed to why don't they call it the Delaware two-step?
Yeah. So Texas in its business code has a provision that allows a company to divide, and they call it a merger. So it seems odd for sure, but it's really designed for this purpose. They split the company and they call it a merger, and that allows the company to do this, to put all of their assets in a company and their liabilities, and it is crazy.
So if I have student debt, let's say, and I am in arrears on my electric bill, and I haven't made my car payments, can I file in Texas that the Sam Seder that owes this stuff is a separate entity from the Sam Seder who's making money on the majority report, and then basically just say good luck, guys, from getting it from the deadbeat Sam Seder?
Yeah, but
we can't, right?
You can't because of this. I mean, this is a bailout for the wealthy. I mean, so to do this, to go through the bankruptcy, I mean, it would cost hundreds of millions of dollars to, what J&J has spent hundreds of millions of dollars in this bankruptcy process. So for a student debt, it wouldn't make sense to go through that process. It's really a bailout for the wealthy corporations, and we've seen it
because they're on the hook.
They're on the hook.
Much more than $100 million.
Exactly. I mean, exactly. They have to spend a lot of money, but they save tons more. If
How
they can
much
get by with it.
money has Johnson and Johnson made up until 1920 when they 2020 when they switched to cornstarch? How much money did they make from talc sales
Yeah,
over the course of?
yeah, I don't know. It's a ton of money because they've sold talc for it's 100 years, and so,
It's
but
got to
it's more
be
than it's
a
more
billion.
than oh yeah, yeah.
I mean, multiple billions,
Yes,
right?
yes. But it's not just the sales from from the baby powder that's driving J&J and J&J's actions here. I mean, the company Johnson and Johnson has lots and lots of products, medical products, pharmaceuticals, consumer products. They've got a lot, but it's baby powder that they consider their golden egg. I mean, it was their image.
Right.
I mean, the baby powder, I think, is the most familiar smell in the world. I mean, it's up there. So it was their iconic brand. It was tied to their image. That was more of a driving force than just the sheer revenue from the baby powder.
It was image and reputation and
that's right.
And then why do they move to North Carolina? Why does the sort of Johnson minus Johnson essentially at that point? What do they call that company? Or is it?
Well, they called the company that they formed and moved to North Carolina was LTL. Legacy Talc Liability. So they moved that company.
That's
to North
the name
Carolina.
of the company. That's very catchy.
LTL. Yeah, exactly. But they moved it to North Carolina because North Carolina was known as a bankruptcy haven for asbestos liability companies, and so there were a number of cases that were pending, in North Carolina. North Carolina bankruptcy courts were favorable to those companies, and the Fourth Circuit Court of Appeals was a favorable venue. So they moved there because the first Texas two-step was the Koch brothers in Georgia Pacific, and so there were several of those Texas two-step bankruptcies that were pending in North Carolina, and they bought these companies a tremendous amount of delay. It just stops all of those cases in their liability.
Is there a coincidence between Texas being the state where you can basically surgically remove as a corporation your liabilities from your assets, and then North Carolina being a state where if you're just a company holding a bunch of liabilities, you can get some bankruptcy relief if it's around asbestos, with who controls those legislatures and who gets elected to the state courts and who the governor is? I mean, or is that just a coincidence?
I think that's more of a coincidence. I think that's a bankruptcy law firm, Jones Day, who created this Texas two-step. I think that's them seeing, okay, what's available in Texas and what can we get in North Carolina and putting.
But is that
steps.
available in Texas because you have lawmakers who are creating an environment that is more amenable to corporate malfeasance in North Carolina? I mean, why isn't that happening? Why is just like it? Why is Texas law so quirky and not, let's say, I don't know, Massachusetts?
Yeah, that's interesting, Sam. I mean, so we've had some statements from some of the legislators that were involved in forming the Texas business code that allows that divisive merger, and they say that was not our intent. That was not the intended use of this statute. I think it is.
Can they go back and fix it?
Oh, they could. Hopefully they will. But I think more importantly, we need the U.S. Congress to step in, and there's some bills pending that would address some of the abuses in the bankruptcy.
But if your case is a federal case, why does state law? I mean, state law, I guess, allows them to change the nature of their entities, but they're still like, why can't you continue to hold, like, you can do all this in Texas, but we're suing you in federal court.
Right.
And as far as the federal court system is concerned, you still have this liability.
Right.
Why doesn't that happen?
It's not so much an issue of who has the liability. I mean, because Johnson and Johnson I mean, we have the evidence to show Johnson & Johnson's on the hook. The parent company is on the hook, and we will continue to pursue that. But one of the most egregious aspects of bankruptcy here is that you have Johnson & Johnson, a $400 billion company, and they are getting the benefit of bankruptcy. So they file their subsidiary, and then the bankruptcy, one of the things that they ask for immediately in bankruptcy is stop all of the cases, not just against the debtor, that subsidiary LTL. Now it's Red River in their third bankruptcy. We're now facing their third bankruptcy here in Texas, and it's a new subsidiary called Red River. But the bankruptcy courts stop all of the lawsuits, not only against that debtor, but against the parent company as well. So we could go forward. I mean, there is liability against Johnson & Johnson because they were the ones that were making these decisions, right. And so we can hold them liable. But the bankruptcy code and the bankruptcy courts are stopping all of the lawsuits. That's one of the most harmful aspects of this, and the most egregious is because they are using the bankruptcy to stop juries from holding them accountable for what they've done.
So you have tens of thousands of people out there who have gotten ovarian cancer from this talc.
Yes.
And they have no recourse at this moment because the bankruptcy court is saying, these made up companies essentially,
right.
Their bankruptcy protection extends to Johnson & Johnson.
That's what we're fighting. So they moved to North Carolina, the North Carolina Bankruptcy Court. This was in their first bankruptcy. The North Carolina bankruptcy judge said, no, this case should be transferred to Johnson & Johnson's home base in New Jersey. So it was moved to the bankruptcy court in New Jersey. The bankruptcy judge in New Jersey, we filed to get it dismissed, saying they're not entitled to bankruptcy relief. The bankruptcy judge denied it, but we appealed it to the Third Circuit Court of Appeals, and the Third Circuit agreed with us. And so the Third Circuit ordered that the bankruptcy case be dismissed. Johnson & Johnson's not in, there's no financial distress here. You're not entitled to bankruptcy relief. So it was dismissed. 2 hours and 11 minutes after that bankruptcy case was dismissed, Johnson & Johnson filed again. They filed their second bankruptcy in that same court, and they had stripped about $30 billion in assets away from that subsidiary or from the funding agreement, and said, okay, now we've got financial distress. The bankruptcy, so we had to fight another motion to dismiss. This time the bankruptcy judge dismissed the bankruptcy. J&J appealed it to the Third Circuit. So there's been this delay after delay after delay, which is,
how does that end? Or is it just that the Johnson & Johnson realize, is it bad press? Is it it seems like they have an endless amount of money to spend on their attorneys.
Yeah, they do.
I mean, how does this cycle end?
Yeah. So now they filed their third bankruptcy, this time in Houston, and it would be in the Fifth Circuit Court of Appeals. So they're trying to get a different, hopefully we'll
this
get
audience
this
is familiar with the Fifth Circuit because it's, there's a lot of jurisdiction shopping that's been going on for a lot of corporate friendly, also, social issues in the Fifth Circuit.
So we have a hearing on a motion to transfer venue to try to get it transferred back to New Jersey, and that's tomorrow, and then we'll see what the bankruptcy judge
Why
does.
won't they just do number 4 and 5 and 6?
Yeah, I mean they could, unless somebody steps in, and so there are a couple of forces hopefully that will prevent that from happening. I mean, and one is Congress. So you have Congress that is considering. They have been watching what J&J has been doing, and there's some bills pending now that will
Where do
curtail.
those bills come out of? Like what committees?
They come out of judiciary.
Okay.
The judiciary committees, and so hopefully those will gain momentum, especially now that J&J has done it for the third time.
Is there bipartisan support for these things?
Yes,
there is.
Yes.
Okay.
Yeah. So you have Senator Josh Hawley, Republican from Missouri, and Sheldon Whitehouse, Dick Durbin, have co-sponsored a bill in the Senate Judiciary. So there is bipartisan support, and it seems to be momentum as people are seeing the third time. Come on, you've got to be kidding me. So there's hopefully Congress will help stop the fourth when we get this one dismissed. And then there's also some pressure, I believe, from shareholders, and their investors are, they're fed up with this, J&J just continuing to, drag this out instead of, because Johnson & Johnson clearly could do the right thing by these victims. They could.
I would imagine at one point too, like the more exposure this story gets, the worse it looks for Johnson & Johnson. I mean, you can protect the sort of like the image of the company with the baby powder, but not if people understand, because I don't think most people understand.
Right. I mean, the machinations that J&J has employed here in these bankruptcies, filing the third bankruptcy, some of the things that they did to try to manufacture a favorable vote among the creditors, the more that is exposed, I mean, the worse J&J's image is tarnished.
And one of the things that I would imagine a firm like yours has to do is you've got lawyers working on this. Johnson & Johnson has millions and millions and millions and millions of dollars where they have in-house lawyers and they bring in other counsel, and this is the cost of doing business. They may spend $100-200 million on lawyers, but they're saving multiple times that. From your perspective, you guys are doing this mostly on spec, right? I mean, so you've got to have a big reserve of cash. I mean, does a Johnson & Johnson look at a firm like yours? I mean, I know that's the difference. Like, one of the strengths that Levin Papantonio as a firm has, was a firm that was involved in the tobacco settlement. So they have long-term, they have resources. Yeah. Does that like make a Johnson & Johnson, like if it was me and like I had a single shingle up and they just go, we're just going to bleed this guy.
Yeah, exactly. Well, I mean, what we're seeing here, I mean, it's a war of attrition. And I mean, that's what J&J is counting on. It's the same strategy that was employed by the tobacco companies in the tobacco litigation. We'll litigate you to death. And they're counting on the ovarian cancer, these cancer victims, just to grow tired and weary, and the lawyers that are representing them to grow tired and weary, and that they will take pennies on the dollar. But J&J has seriously underestimated the resolve of the cancer victims, and they've underestimated the resolve of the firms that are representing them.
Andy Birchfield, thank you so much for your time today. Really appreciate it. Fascinating stuff.
Great to be with you, Sam.
Thanks. Hey folks, don't forget to hit the subscribe button and check out our daily show. We do it every day at 12 p.m. Eastern for about 2.5 hours. We even take phone calls. You should check that out.